This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. All right, so this woman came to the United States in 2002. She married her husband in 2010. The husband does not have any lawful immigration status, meaning he's not a green card holder or a U.S. citizen. The couple had a child together, and after the child was born, the husband became controlling, and on a few occasions he was physically abusive. She was afraid to call the police due to fears of getting deported or angering her husband even more and having him increase the intensity of the abuse. But eventually, at her family members' urging, she called the police and the husband was arrested. She has filed for a restraining order against the husband. The couple does not currently live together, as she has moved out and now lives with her sister. The family wants to know if we can pursue an immigration case for her. All right, so this sounds like it's a viable U visa case. All right, it wouldn't be a VAWA case because the husband is not a U.S. citizen or a permanent resident. So the only thing we have left is a U visa case. In order to do this, we need to get a law enforcement agency or a judge to sign off that this woman has been the victim of domestic violence and that she was cooperative in the arrest and the investigation or prosecution. It's not clear from this if the prosecution is currently ongoing with the husband or if the charges were dropped. None of that is really stated. But if the prosecution is ongoing, then we can talk to the DA, the district attorney, to see if they will sign off on all of this, that she is cooperating. If it's been dropped or they didn't feel like they had enough evidence to move forward with the prosecution, we would likely want to go to the judge that handled the restraining order. Okay, that, at least in Orange County, we've had a lot of success reaching out to the judge that handled the restraining order, asking them to sign off that she was cooperative, and a lot of those judges are willing to do that. So that would likely be the first step, is getting that LEA or law enforcement agency certification. Now, the reason this isn't a VAWA case, well, we already went over that the husband's not a U.S. citizen or a permanent resident. But what's the difference between the VAWA or the U visa case? The U visa will likely take somewhere along the lines of 7 years, in that ballpark, to get approved. And then after that, you have to wait another 3 years to go for the green card. With VAWA, you don't have those long wait times. All right, so if we can do a VAWA case, that is better. You can get those finished within a year or two generally, depending on processing times. But that's not an option here. Okay, because the husband, again, doesn't have any status. So once we file the U visa case, all right, we filed the LEA certification, we've gotten that back approved, now we file the U visa case. Then we're probably going to wait about a year until we get a prima facie determination. And what that does is it says that the government has looked over the case and they believe that this is a legitimate case. We can take that, and that can be used to, first of all, get certain benefits, but also the client can carry that with them. And if they're stopped by ICE or anything like that, maybe that will help. Or if they get put into removal proceedings, we can show that to the immigration judge as a way to say, look, we have a pending case. It's already been deemed legitimate and viable. You should not order this person deported. So that prima facie determination is very valuable. That also allows you to get work authorization if you have the prima facie determination. So with that work authorization, now you can work legally in the United States. If you are stopped by ICE, you have that card, and that should help you avoid being detained or put into removal proceedings. If you believe that a U visa might be something that you are eligible for, it's not just for domestic abuse cases, okay? This can be any serious crime, armed robbery, assault, felony assault, that sort of thing. Any one of those very serious crimes can make you eligible for a U visa. So if that sounds like something that you've gone through, then reach out to us. We can sit down and talk to you about it and figure out if this is a viable case and worth pursuing. Hopefully this helps inform everyone a little bit more on U visas. Give us a call if you need any assessments or have any questions. Good luck.